I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party. You're a named man.
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
All right. Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it.
Then there are the mysterious Whitlows.
Go ahead.
There's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know
Buckle
that
up, guys, because today's courtroom hearing turns into absolute chaos within seconds. What starts as a simple eviction case quickly spirals into accusations of fraud, mysterious bankruptcy filings, disappearing parties, and $1 million property trapped in legal warfare. The attorney begins laying out a timeline so bizarre that even the judge seems stunned, revealing claims that multiple people may have used bankruptcy courts to delay the eviction process over and over again.
I don't know that I need that because I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then you can go challenge it. With who?
With Whitlow. Ms. Whitlow.
Then you need to go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to.
I don't know what you need to do, but
Well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that I stated that I'm not. Oh, I lost my spot. Not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment. Oh,
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
okay.
You know what? Here's the problem. You've not filed anything with this court. So I don't know why, on those grounds, why I'm hearing from you.
Okay. if I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and counterclaim to what?
to their complaint for eviction.
You have a lease with
The tension completely shifts once the alleged occupant finally tries to defend herself in court. From the outside, it immediately becomes clear that her strategy is falling apart in real time. She first rejects the court's jurisdiction, only to suddenly reverse herself moments later after realizing the consequences. The judge quickly locks onto the contradiction, shutting down the confusion, and repeatedly pointing out that she was never officially part of the case to begin with.
allegedly with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing. Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in 10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract with. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know that.
Okay. I know you don't know that 'cause it's not before you.
Correct.
I see. I see. So basically the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, you're stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have right to own the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right. Based upon the representation of counsel, I'm going to grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment and order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter. It is a
At this
significant
stage,
property.
The courtroom starts moving toward a final decision. The judge carefully explains that any agreement the occupant claims to have is not with the current property owner, but with the missing individuals connected to the lease. Meanwhile, the court grows increasingly frustrated with unsigned filings, absent parties, and unsupported claims. Then comes a major turning point. The judge grants the eviction order, sets a massive appeal bond, and makes it clear the delays are
It is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order. Thank you.
Thank you, Your Honor.
Thank you.
Okay, hold on.
I'm sorry.
No, it's okay. I'm not worried right now. Let me just say this. I won't worry at this moment about November, but you put in your motion that you were going to get October paid, right?
Yes.
Okay.
Your Honor.
Hello, what's your name?
Liana Jones.
Okay, you need to take your hands out of your pockets if you would. Thank you. All right, is this your motion to set aside?
Yes.
All right, what's your basis on setting that aside?
I'm sorry.
Pardon?
I didn't hear you.
What's the basis of which you want the judgment set aside?
Oh, because I had missed the first court date because the lady, I had made a payment for September and she told me don't come to the court date if I had made.
She who told you
The
that?
lady in the office at Arbor One Apartments.
Okay, let me ask this. What's her current balance?
Current balance, $2,464.94. Your Honor, the motion states that she's going to pay her balance by October 31st, which she has not done.
No, I wasn't able to. My car had broke down again, but I can make a payment of $900 that's on the judgment on Monday. That's most. of the
Okay, so,
judgment.
here's the problem. The problem is that the judgment was from October. You don't have October paid, and now I've got November.
Yes, and I have started an application with I don't know what the program is called. It's for them to help me pay my rent.
Hawk,
Yes.
you got an application with Hawk?
Well, I got an appointment on Monday.
Young lady, did you have an appointment with Hawk or no?
I have an appointment on Monday. I had talked to them already, but then I had to get it.
You have an appointment this Monday?
Yes.
Do you mind if I get a confirmation of that? Amy, do you know?
She has an appointment coming up on the 18th.
You don't have an appointment till the 18th.
That's not this Monday.
Well, that's not this Monday, but it's next Monday.
Right.
But in the interim, how much has she paid since October 11th, Ms. Luckoff?
Give me 1 second, Your Honor. The last payment made was October 1st. Nothing has been paid since October 1st.
I asked
For a basis to set aside the judgment at this point. She's not presented a meritorious defense. If we give her the credit for what she's saying, why she didn't come to court the first time.
Right, but I was a bit confused because she said she paid $800.
No, I paid because the first time this was ever brought out was from September, and I paid September's rent, and she told me do not come to the court date because I made a payment. Then it dragged over into October.
Your Honor, they never.
The first hearing date was October 11th.
Yes, but that was for September's rent.
No, it includes October rent at that point.
Okay.
I know that what the complaint may have said, but your October rent would come due. That's why there was $1,194.
Right. I can make a payment of $900 on Monday for the job.
Okay, so young lady, here's my problem. My problem is why don't you at least have the 1194, which would be your October rent?
Because I had lost my job, my car broke down, I had to use some of my rent money to get my car fixed. I wasn't able to pay.
No, I hear you, but you see the problem? Because now I'm sitting here at a hearing in November, November's rent is due.
You're right.
That's what the problem is. And then even if I take the benefit of the doubt of what you tell me you can do, right? It doesn't even pay through October. And then I've got November.
Right.
Okay, no.
The second hearing introduces a completely different kind of pressure. Instead of legal confusion and courtroom maneuvering, this case centers around financial struggle and survival. A 10 explains how missed rent payments, unemployment, and car problems push her deeper into debt after missing an earlier court date. The judge listens carefully but keeps returning to the same hard reality. The unpaid balance continues growing while deadlines keep getting closer and closer.
What can you come up with between now and the 15th? You said you had 900.
Yes. That's for October, and I was expecting the people
Hold on.
to help me with November's rent.
Okay, hold on.
I'm sorry.
No, it's okay. I'm not worried right now. Let me just say this. I won't worry at this moment about November, but you put in your motion that you were going to get October paid, right?
Yes.
Okay. You got 900 right now, right?
Yes.
Okay. Is her rent about 1,200, Ms. Luckoff?
Yes.
Is that about right?
Let me check.
Because I had 1194 on the judgment, and then it sounded like
For rent, I mean, the base, I'm sorry.
Go ahead.
It's 1065 for the base, and there's water, trash, gas. So it's 11, yeah, it's about 1140.
Okay, so about 1,200, whatever.
Yeah.
Okay, but you got 1194 because you got court costs in there, you got all that kind of stuff in there.
Correct.
All right, look, young lady, you got a meeting with Hawk on the 18th, right?
Yes.
There's some funding coming in that may be able to cover you for November, even if it went into December. So just listen. But what has to be paid is this judgment has to be
yes.
paid.
So if I pay the judgment on Monday,
Well, how much can you pay on Monday?
well, I'm gonna have guaranteed 900 on Monday, but I can ask to borrow $200 I'm owed
Well, you need $1,200.
for the judgment.
Well, I need $1,200 by Monday.
Okay.
Can you get that paid?
Yes, I can. Yes,
Can you?
I can try. Yes, I can ask to borrow on Monday.
Oh,
I mean, I can
look.
ask to borrow for Monday. I know I could come up with 1,000, but I'm not sure. I'm not sure about the other 200.
Here's what I'm going to tell you. This is the only way we're going to salvage it. And I shouldn't give you this, and I'm doing this over the objection of plaintiff. Okay? Because it seems to me you found yourself in a spot you don't even know what to do to get yourself out right now. Right?
Yes.
So I'm going to give you a chance to try to get it done.
Okay.
And over the objection of plaintiff, I'm going to adjourn you out 1 week on your motion to the 15th at 12 p.m. You need to pay the $1,200. I'll make it by the 13th, which is because Monday's a holiday, and I'll give you a day. So that's that Wednesday. If it gets paid to them on the 14th, I'm not talking about it anymore.
Okay.
You need to get it there by the 13th. All right? Then you've got an appointment at least coming up on the 18th with Hawk. And let's see then if we can get your November paid and salvage your tenancy. You follow me?
Yes. Thank you.
And so I'll adjourn the motion out to that date at that time. Get that paid, young lady. If it's not paid, I'm not going to be listening to you.
The final moments bring both courtroom battles together in a powerful way. In the first case, the courtroom collapsed under contradictions, delays, and procedural chaos until the judge finally imposed order. In the second, the pressure came from desperation and limited time rather than legal games. But both hearings ended with the same message hanging over the room. Eventually, reality catches up to everyone. like the video, subscribe to the channel, and we'll see you in the next video.